rise. Welcome to the 2023 State of our Judiciary. Presiding Justice of the Appellate Division, 4th Department, Justice Gerald Whalen. Presiding Justice of the Appellate Division, 3rd Department, Justice Elizabeth Gary. Presiding Justice of the Appellate Division, 2nd Department, Justice Hector Lozal. Presiding Justice of the Appellate Division, 1st Department, Justice Rolando Acosta. The Acting Chief Administrative Judge of the United Court System, Judge Jamaica Amber. The Associate Judges of the New York State Court of Appeals, Judge Jenny Rivera, Judge Michael Garcia, Judge Rowan Wilson, Judge Belinda Singers, and the Acting Chief Judge of the State of New York, Judge Anthony Cannataro. State of our Judiciary will now begin. Please be seated.
So good morning, everyone. It's great to see you all in person. On behalf of the Acting Chief Judge, Tony Cannataro, and myself, welcome to the 2023 State of our Judiciary. I thank each of you for being here, especially on this snowy morning. It's such an honor to be in this beautiful courtroom today with so many extraordinary members of our court family. And thank you all for all that you do to ensure justice for all of our court users. It's especially thrilling to be here today, as it's the first time in 3 years that we've had an in-person State of our Judiciary. So it's been since before the pandemic that we were all here together for the State of our Judiciary. It's also the first time that Acting Chief Judge Tony Cannataro will be presenting the State of our Judiciary as well. To begin, we would like to welcome 5-year-old Owen Gerstoff, who is a kindergarten student at Pine Hill Elementary School and the son of Stephen Gerstoff and his mom, Ann. I see his mom is here as well. And Stephen Gerstoff is the senior law librarian for the Court of Appeals. So Owen will now lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Owen. Thank you very much, Owen. That was really fantastic. Great job. So now we're going to invite Court Officer Sergeant Peter Robinson of the 8th Judicial District up to the lectern to sing the national anthem.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Thank you very much, Sergeant. That was fantastic. Really fabulous. So now, please be seated, everyone. I'd like to take a few moments to acknowledge some of our guests. Today, beginning with the Associate Judges of the New York State Court of Appeals, the Honorable Jenny Rivera, the Honorable Michael Garcia, the Honorable Rowan Wilson, and the Honorable Madeline Singas. Unfortunately, the Honorable Shirley Troutman was unable to be here with us today. She had a prior engagement. It's also my distinct pleasure to welcome the presiding justices of the Appellate Division. The Honorable Rolando T. Acosta of the First Department. The Honorable Hector LaSalle of the Second Department. The Honorable Elizabeth Gary of the Third Department. And the Honorable Gerald Whalen of the Fourth Department. Also, welcome to former Court of Appeals judges, the Honorable Robert Smith, and the Honorable Susan Phillips Reed. Now I'd like to take a moment to acknowledge the Deputy Chief Administrative Judges for the Unified Court System. The Honorable Edwina G. Richardson Mendelson, Deputy Chief Administrative Judge. The Honorable Norman St. George, Deputy Chief Administrative Judge for courts outside of New York City. And the Honorable Deborah Kaplan, Deputy Chief Administrative Judge for the courts within New York City. And welcome to the former presiding justice of the Appellate Division, Honorable Karen Peters. I'm not sure if she's here today. She didn't make it because of the weather, but we can still give her a hand anyway. I'd also like to welcome all of the Appellate Division justices from throughout the state who have joined us here today. So thank you all for being here. And of course, last but certainly not least, the administrative and supervising judges of the Unified Court System. So thank you all for being here. And now it is my distinct pleasure to welcome our acting Chief Judge, the Honorable Anthony Cannataro. During his tenure as Chief Judge, he has led the Unified Court System with resolve and determination, intent on ensuring that our court users get the expedited justice to which they are entitled. Despite challenges and obstacles, of which there have been many, Acting Chief Judge Cannataro's devotion to the mission and purpose of the court system has remained resolute and unwavering. He has a reputation for not just being an esteemed and revered jurist, but also for being, more importantly, a good and decent person. So please join me in welcoming the Acting Chief Judge of the State of New York, the Honorable Anthony Cannataro.
Thank you, everyone, and good morning to all of you. On behalf of the entire Court of Appeals including Senior Associate Judge Jenny Rivera and Associate Judges Michael Garcia, Rowan Wilson, Madeline Singas, and Shirley Troutman, welcome to the 2023 State of our Judiciary. Let me start by saying thank you to Owen Gertzoff for leading us in the Pledge of Allegiance. I guess he had another engagement he had to run out to. It's busy when you're good at that. And to Sergeant Peter Robinson for his beautiful rendition of the national anthem. I also want to extend my gratitude to Lisa LaCour, the clerk of the Court of Appeals, and to Ann Byer for all their hard work in organizing this event today. And a special thank you to Kristen Kenny from my office, who helped me in preparing today's remarks. And of course, thank you to all of you who are present here today. It seems sometimes as if nothing is easy in the courts these days, and of course, the first major snowstorm of the season would happen today. And I just want to mention Judge Reed would have been here, but for the weather. She's trapped on a hill covered in ice somewhere. But thank you all for the effort in coming here today. It is deeply appreciated. As acting Chief Judge, I am honored today to bring the leaders of our court system together in our magnificent courtroom here at Court of Appeals Hall. Due to the COVID-19 pandemic, our last two State of the Judiciaries have been virtual presentations, and this year, we are fortunate to have the opportunity to host a small gathering of our court family, those who drive, lead, and carry out our unfaltering mission to deliver equal, impartial, and timely justice to all. Complemented by our live stream, we are pleased to update the public, our partners in the justice system, and our fellow co-equal branches of government on the progress we have made over the last year. This annual occasion also provides a chance for us to shine a light on the hurdles our justice system faces moving forward, offer insight into the measures we are taking to address these challenges, and identify the areas in which we plan to work with our partners in government and the broader legal community to most effectively fulfill our constitutional duties to New Yorkers. There can be no question that 2022 was a year marked by transition. We emerged from two very challenging years in which our court system, like our community at large, was compelled to modify its operations during an unprecedented global health crisis in order to ensure the safety of our judiciary, our workforce, and court users. And we transitioned to a court system that is restoring its calendars to pre-pandemic numbers, making every effort to cut down on backlogs that accumulated during the pandemic, and modernizing its operations to enhance efficiency and increase access to justice. Although we have experienced uncertainty over the last 6 months regarding the ongoing transition in court leadership, I am proud to say that our courts are open and operational. Our judicial and non-judicial personnel continue to deliver high-quality justice to all who enter New York's courthouses. And our experienced administrative and supervising judges are hard at work ensuring that we are meeting appropriate benchmarks. As we move further into 2023, we will continue to expand our operations, tackle our caseloads, and improve every facet of our justice services. In the years preceding the COVID-19 pandemic, our criminal and civil courts made remarkable strides in clearing backlogs, reducing the numbers of cases pending, and minimizing delays. Unfortunately, the sudden onset of the pandemic in 2020 caused setbacks to that progress by necessitating significant alterations in our in-person operations to minimize transmission of the virus. In 2021, we forged ahead with hybrid operations firmly in place, and we worked towards restoring our in-person operations to pre-pandemic levels. With the resumption of full trial capacity late last summer, our ascent from pandemic-related backlogs picked up steam in 2022, and our courts resolved more than 2.1 million cases across the state, delivering justice to millions of New Yorkers in the process. New York's criminal courts conducted over 430,000 arraignments and over 2,100 trials in 2022, representing a 68% increase from trials over the prior year, with more than half involving felony matters. Overall, dispositions in local criminal courts surpassed 745,000 cases, a 57% increase from 2020. With a concerted effort by our judges and court personnel, we have also made significant progress in resolving older criminal cases. Courts outside of New York City significantly reduced pending misdemeanor caseloads by over 5,500 cases from the prior year. Meanwhile, in 2022, New York City criminal courts achieved a notable reduction of over 600 misdemeanor cases pending for more than 1 year, with over 2,700 resolved since the height of the pandemic. With respect to our felony dockets, almost 1,500 fewer cases across the state were over standards and goals at the end of 2022 than were pending at the end of 2021. Our commitment to reducing backlogs is reflected in initiatives like the Rock Group in our 7th Judicial District, led by Administrative Judge William Taylor, a collaborative effort to focus attention and resources on resolving older cases, ROC. The Rock Group, comprised of judges, clerks, attorneys, and staff, closely tracks case trends, makes data-based adjustments to the allocation of resources, and carefully distributes trial-ready criminal cases to facilitate a steady, deliberate reduction in older pending cases. New Yorkers can rest assured that their criminal courts are taking proactive and creative approaches to managing resources with a view towards tackling caseloads and rebounding from pandemic backlogs. We know that the timely disposition of criminal matters involving firearms is of grave importance to New Yorkers who want their families to feel safe from the dangers of gun violence in their schools, in their homes, and on their streets. As part of coordinated efforts to mitigate gun violence in New York City, our dedicated gun parts have been prioritizing and expediting gun possession cases, bringing more than 2,600 cases to disposition since late April 2022. Indeed, despite the addition of more than 1,700 new gun cases to our calendars, the inventory of gun cases pending in New York City has dropped by approximately 33%. Similarly, in just over 2 months of the ongoing citywide robbery initiative, the criminal term of New York City Supreme Court decreased its pending first-degree robbery cases by 10%. Deputy Chief Administrative Judge Deborah Kaplan has been instrumental in spearheading our efforts to resolve the oldest pending cases, as well as the other cases just mentioned, and measures such as intensive case conferencing and the shortening of adjournment periods provide the foundation for our successes in the gun and robbery initiatives. As we undertake a coordinated push to resolve the oldest pending criminal cases in which defendants are incarcerated, additional judges will be receiving training in how to replicate these strategies in their own courts. Make no mistake, our criminal courts have more work to do on minimizing delays and adjudicating cases that have lingered for far too long. When individual liberties and freedoms are at stake, the need for careful but prompt justice is paramount. But as we continue to single-mindedly reduce our caseloads, it also bears noting that there are real people behind each data point demonstrating the progress already made in resolving pending cases. Defendants, victims, and families who all feel heard, who have received some measure of closure, and who can begin to plan for the future. The last several years have not been easy for any New Yorker. I am proud of the work done in 2022 by our judges and court professionals and of their steadfast commitment to eliminating bottlenecks in criminal matters so that our communities can receive justice. On the civil side, our disposition of pending matters has increased by 34% since 2020 and by 6% since 2021, with over 877,000 dispositions throughout the state. Almost 8,700 trials were commenced in local civil courts during 2022, which is a 44% increase from the prior year. Under the leadership of Deputy Chief Administrative Judge Norman St. George, our Supreme Courts outside New York City in particular have achieved marked reductions in the volume of older pending cases. Thank you, Judge St. George. Statewide case resolution trends in family court are also promising, with almost 439,000 matters resolved in 2022 and dispositions increasing by 13% since 2021, despite an almost 20% increase in new filings. Our family courts in the 5th Judicial District, overseen by Administrative Judge James Murphy, reduced pending caseloads by 600 older cases last year and over 1,000 since 2021. With the expiration of pandemic foreclosure protections in early 22, many feared a surge in foreclosure filings. But while there have certainly been new cases filed, I am happy to report that several of our counties are experiencing the lowest number of active pending foreclosures in over a decade, due in no small part to the tireless service of our judges and non-judicial personnel. Filings have not outpaced dispositions. We continue to encourage New Yorkers to take advantage of alternative dispute resolution early in the litigation process. These forums often lessen conflict, decrease cost, produce satisfactory outcomes, and increase efficiencies in our dockets. Over 12,000 cases were referred to mediation in 2022, and 58% of mediated cases reached a full or partial settlement. In addition, more than 8,000 cases were resolved through arbitration, and at least 1/3 of the cases using early settlement conferences achieved resolution. Through the efforts of our statewide ADR coordinator, Lisa Courtney, as well as our regional ADR coordinators, Bridget O'Connell, Joel Coolis, and Jean Norton, much work has been done to grow our ADR infrastructure. Supreme Court Bronx County, for example, created and staffed new ADR programs for tort and matrimonial cases. Richmond County Supreme Court likewise established an ADR program and undertook significant efforts to educate court users on the value and availability of ADR. Projects such as these will allow us to see accelerated and sustainable expansion going forward. Of course, the extraordinary work of our justice system extends beyond the trial courts. With the invaluable guidance of Presiding Justice Gerald Whalen, the Appellate Division 4th Department reduced its backlog of cases caused by the onset of the COVID-19 pandemic by 100%, entering the September 2022 term with no cases carried over from the previous terms. Likewise, for the 3rd year in a row, under the superb leadership of Presiding Justice Rolando Acosta, the Appellate Division 1st Department entered its September term with 0 pending argued appeals. The 1st Department also shortened the average time frame between argument and decision publication to the court's shortest turnaround time in about a decade. The 3rd Department, excellently administered by Presiding Justice Elizabeth Gary, continued its proud custom of entering the new 2022 term with no holdover appeals, and on average reduced by almost 1 full month the time between perfection of an appeal and the court's decision. And with the inimitable Presiding Justice Hector LaSalle at the helm, the 2nd Department, our busiest appellate court, has made impressive progress by reducing its criminal appeal caseload by almost 50% between 2019 and 2022, and its civil caseload by 10% from 2021 to last year. Thank you, PJ LaSalle. At every single level, New York's courts have demonstrated a remarkable dedication to overcoming challenges and delays attributable to the pandemic. With that said, we acknowledge that backlogs persist and that there is more progress to be made. The UCS leadership team, our judges, and our non-judicial personnel are working hard to maximize efficiencies and shift resources to reduce stress on overburdened courts and to keep our dockets moving swiftly. The state of our workforce is a key factor in our ability to cut down on backlogs while still meeting the demands of new filings. Over the last year, we have experienced unprecedented rate of attrition due to resignations and retirements, many of which were spurred by the pandemic and an increasingly competitive job market. Attrition, combined with a temporary hiring freeze during the pandemic, has left us struggling to adequately staff our courtrooms with court officers, court reporters, and interpreters, and to ensure that our IT departments are able to meet the technological needs of our judges and back office personnel. Needless to say, staffing shortages slow down our dockets and burden our already strained workforce. We can all agree that our people on the ground, from our judges to our court officers, administrative professionals, court attorneys, and building staff, are the driving force behind the court system's ability to deliver high-quality justice services to the public. For that reason, we are working to increase our non-judicial position fill levels by 800, and our recent budget request seeks to facilitate a return to pre-pandemic staffing levels, accommodate 3 new academy classes of court officers, and allow for the creation of 270 additional non-judicial positions to support newly created judgeships, something we have not done in over 14 years. Justice delayed is justice denied, and it is imperative that we have sufficient staff support for our courts to deliver justice expeditiously. Our courts also operate more smoothly when our partners in justice are adequately staffed. For 19 years, private attorneys appointed by our courts to represent indigent defendants in criminal matters and children and parents in our family courts have faced stagnant compensation rates. The services these Article 18b attorneys provide to their clients protect the vital rights of indigent defendants and safeguard the important interests of New York's families. In recent years, we have experienced a significant decline in the number of attorneys participating in our 18b assigned counsel programs. But today, prospects for an increase in compensation rates look better than they have in the past few years. We thank Governor Hochul for addressing the matter in her most recent budget proposal, and we remain ready and willing to assist our governmental partners in resolving this important issue. Competent legal representation also facilitates fair and timely resolution of housing matters. More than 5 years ago, New York City enacted a local law to increase access to legal representation for low-income New Yorkers facing evictions. However, the program is subject to the constraints of available funding and the ability of legal service organizations to keep up with demand. This past year, over 104,000 residential eviction filings were filed in the New York City housing courts. But participating legal service providers declined to represent thousands of tenants, in large part due to a shortage of attorneys for caseloads that we know often leave them feeling overworked, underpaid, and emotionally drained. Nonetheless, while only about 30% of tenants appearing in holdover and non-payment cases resolved in 2019 by our New York City housing courts were represented by counsel, in 2022, 51% of appearing tenants in those cases resolved had legal representation. Despite the challenges faced by the city's Universal Access Program, the law simply does not permit our housing courts to grind to a halt. Justice Carolyn Walker Diallo, Administrative Judge of the Civil Court of the City of New York, and Judge Jack Stoller, our citywide supervising judge for the housing part, continue to work closely with New York City's Office of Civil Justice, the mayor, institutional service providers, the bar, and law schools to address this issue. We are committed to supporting creative strategies to augment the availability of legal representation in housing cases to enable the speedy resolution of disputes and to minimize resort to eviction. In the meantime, our housing courts will continue to assist tenants and landlords in a fair and timely manner. Many courts around the state have undertaken supportive measures of their own to facilitate increased access to self-help resources and legal representation in housing disputes. In the 10th Judicial District, administered by Judge Andrew Krecka, Administrative Judge Andrew Krecka, the Suffolk County District Courts operates diversion rooms in several of its busiest landlord-tenant courts. These one-stop locations help litigants to connect with attorneys, rental assistance, and housing programs, and we have reports that these convenient and accessible diversion rooms have allowed the court to connect litigants to services in approximately 70% of summary proceedings. Just this past summer, the 8th Judicial District, overseen by Administrative Judge Kevin Carter, celebrated the opening of the Erie County Landlord-Tenant Hub Court, a virtual court that consolidates the county's town and village eviction disputes into one forum that operates through a presumptive ADR model. The Hub Court facilitates landlord-tenant legal representation through a variety of local service providers, and recent reports indicate that the Hub Court has substantially reduced eviction rates in Erie County. Proactive programs like this go a long way toward helping tenants remain in their homes and assist parties in forming plans to avoid future disputes. It is a grim reality that many low-income New Yorkers rely on civil legal service organizations for assistance securing essentials of life, such as housing, healthcare, and educational services. To help, our Judiciary Civil Legal Services Program distributed over $95 million to grantees providing direct legal assistance and access to justice services in 2022. Having reached our goal of securing $100 million in legal services funding in recent years, our 2024 budget request includes a 3% cost of living increase. Looking to the future, our budget requests and expansions of civil legal services will be informed by the results of a funding study currently being undertaken by the Permanent Commission on Access to Justice, chaired by Helene Barnett. This study, which we anticipate will be completed within the next year, aims to provide a realistic estimate of the funding necessary to close the civil legal access to justice gap entirely. And we look forward to that report. Our court system cannot overcome the challenges presented by attrition and attorney shortages by itself. Over the last year, we have taken consequential steps toward modernizing our courtrooms and protocols, improving the culture and operation in our family courts, and executing measures that promote inclusivity and eliminate bias. Moving forward, we will continue to make every effort to review our operations, identify room for improvement, and implement innovative procedures that enhance our delivery of justice services. On technology, we have made substantial strides in streamlining our case management systems, particularly in our criminal courts. This gives trial courts additional tools to aggressively manage their dockets and facilitates quicker and more standardized reporting of case information. A heightened ability to track case data, eliminate abandoned cases from our dockets, and accurately pinpoint case trends is crucial to detecting emerging problems so that we can appropriately distribute our resources across the state. The Appellate Division 3rd Department also undertook a major overhaul of its case management system in 2022, replacing an outmoded database with a more efficient system that has improved service to attorneys and litigants. Overall, the court system's data management is more productive than it has ever been, and we will continue to track our numbers to learn where and how we can refine our operations. We thank the Division of Technology directed by Christine Cesario, and our Office of Court Research directed by Karen Kane for their outstanding job in distilling and packaging our court data in understandable and helpful ways for both internal use and for public consumption. The march to modernize and update our courtrooms endures. We are embracing virtual appearances and proceedings where appropriate, particularly in civil courts where we have more flexibility to do so. Virtual options lessen costs and expenses for the parties, reduce litigant time away from home, work, and family, and ease the burdens on attorneys practicing in multiple courts and geographic locations, especially in rural areas that are experiencing attorney shortages. In our commercial divisions in particular, virtual proceedings have been well received, with over 9,400 virtual appearances this past year in Manhattan alone. Cognizant that open access to court proceedings is often a public right, in early December, we debuted a web portal to provide members of the public and the press the ability to observe virtual court proceedings in Supreme Court throughout the state. Our courts are also exploring the potential benefits and flexibility that virtual jury selection proceedings can offer. Supreme Court New York County completed the state's first fully virtual jury selection, and Suffolk County Supreme Court recently launched its own pilot program in that area. Moving into 2023, the court system continues to learn from the obstacles faced in the initial days of the pandemic, when in-person operations were restricted and virtual capacities limited. Our Pandemic Practices Working Group, chaired by Justice Craig Doran, recently released its final report containing recommendations to build on our virtual capabilities, overhaul our website, and expand our digital filing programs. We thank Justice Doran, our working group members, and Hank Greenberg, chair of the Commission to Reimagine the Future of the New York Courts, for the incredible efforts that have culminated in this report. Acting Chief Administrative Judge Amaker will be creating a multidisciplinary team of experts from all areas of our court operations, including our technology, finance, and administrative departments, to undertake an internal review of the Pandemic Practices Report and, in collaboration with the Commission, devise a roadmap for implementation of the report's invaluable recommendations. More than 2 years down the road, we remain fully cognizant of Secretary Jay Johnson's conclusions that far too often the pace, culture, and physical facilities of our needs of life courts do not suitably reflect the gravity of the matters handled in them. Sadly, this is often a symptom of the fact that these courts are overburdened and under-resourced, and that our staff and judges in these courts are facing emotionally trying matters on a daily basis. Since Secretary Johnson's report, we have worked hard to adjust the tenor of our family courts. We have addressed concerns regarding overcrowding and scheduling. Our trial judges have made individual changes in their own courtrooms to promote respectful interactions between staff and litigants, and our supervising judges are closely monitoring events on the ground. We have also continued to address the problems highlighted in the Equal Justice Report by increasing and mandating anti-bias training for judges and for court personnel. In our family courts, in particular, we have mandated that mediators undergo domestic violence training similar to the biennial training required of our judges. Through a public awareness campaign and the posting of notices in our courthouses, we have encouraged and educated litigants on how to report concerns of bias or unfair treatment. Responses indicate that court users are now more aware of their rights, their responsibilities, and their avenues for recourse than they ever have been before. New York families are experiencing increased financial and emotional stress due to the human and economic toll of the pandemic, together with the rising cost of living. We have therefore taken measures to expand court access for New York families by contributing additional resources to our do-it-yourself filing terminals and broadening e-filing to encompass additional case types and courts. As a matter of fact, e-filing is live in family court in New York and Richmond counties and is expected to expand to Bronx, Queens, and Kings counties soon. Our virtual community court access networks continue to grow, as exemplified by the recent launch of a new site in Red Hook. These networks provide safe and private community-based access to court resources, forms and filings, and assist users to connect with legal services organizations. Hubs located in libraries, places of worship, and other community-based organizations play an important role in making justice more readily available to users who lack technological resources or who have trouble reaching the courthouse, whether due to disability, difficulty accessing affordable transportation, or childcare complications. A partnership between the Suffolk County Family Court and the Brentwood Public Library, for example, facilitates live remote access to family court clerks from library computers. And as of this year, the 5th Judicial District proudly operates 11 virtual access locations across its 6 counties, allowing litigants to appear virtually in many courts via computer at a safe and private location. In addition to providing easier access to the courts, these programs enhance efficiencies on our end, which in turn reduces delays for litigants seeking to resolve the often imperative and urgent legal matters affecting their families. New York City family courts, administered by Judge Anne-Marie Jolly, have seen very positive trends, particularly in support matters, due to virtual appearance options for pro se and represented parties. Our family courts report greater party participation, fewer orders entered on default, and fewer dismissals of support petitions for the failure of petitioners to appear. Virtual proceedings have also generated greater engagement and attendance by adolescent children in permanency hearings. Youth have expressed that they are more comfortable appearing virtually and that such appearances minimize their need to be absent from school. Significantly, when the individuals impacted by our family court proceedings are more actively involved, our judges, referees, and magistrates can fashion more tailored and meaningful orders. Our recent focus on filling vacant referee and support magistrate positions, along with the legislature's creation of several new family court and Supreme Court judgeships, provides much needed support. And in 2022, New York City Family Court reduced its case backlog in all counties. But we still must direct our resources to further reducing the volume of pending cases and to ensuring that all families who enter our courthouses receive the respectful and punctual justice that they deserve. Judge Jolly is reviewing the recommendations contained in the Franklin H. Williams Judicial Commission's recent report on our New York City family courts. Although many of the issues identified in the report have already been addressed, such as overcrowding and pay parity for court attorneys, we will continue to refine our operations for the benefit of all New York families. We are also undertaking a robust and focused response to the recently published report by the National Judicial Task Force to examine the state court's response to mental illness. Former Chief Administrative Judge Lawrence K. Marks co-chaired the task force at the NCSC that produced this important report. After engaging in extensive research, the task force developed tools, trainings, and best practices for state courts to promote systemic and community-level change in our response to mental and behavioral health issues when justice-involved individuals come before our courts. The New York State Department of Health estimates that every year, more than 1 in 5 New Yorkers experience symptoms of a mental disorder, and at least 1 in 10 New Yorkers experience mental health challenges that impact their daily functioning. Far too often, individuals with unaddressed or undertreated mental and behavioral health problems end up in our courtrooms. The task force's report emphasizes that collaborations between our justice system, public health and treatment providers, families, and community organizations are essential to providing early intervention and treatment measures that can prevent escalation before individuals enter the criminal justice system. Once these individuals are before our courts, we have an obligation to provide effective and appropriate competency procedures and diversion options to reduce the likelihood of incarceration and increase the rate of recovery. We have over 300 problem-solving courts and specialized parts throughout New York, many of which are already working toward these goals. Our problem-solving courts, overseen by Judge Toko Sarita, include 42 mental health courts across the state, and we have more mental health initiatives in development. The 9th Judicial District, administered by Judge Ann Minahan, recently launched a misdemeanor wellness mental health court in Westchester County. And in the 4th Judicial District, supervised by Judge Felix Katina, Essex County recently opened a superior part for mental health treatment. Mental health courts offer eligible individuals an alternative to prosecution. They take a holistic approach by providing a range of services, including mental health treatment, substance abuse treatment, housing assistance, and educational and employment training in an effort to address the root causes of criminal activity and break the cycle of recidivism. Guided by the National Task Force's report, we will focus on strengthening our community partnerships and reviewing our existing procedures and protocols to ensure that in every way possible, our courts are taking an empathetic, humane, and effective approach to mental and behavioral health. And I am pleased to announce that Judge Matthew Demick, a pioneer in mental health courts, has graciously agreed to chair a blue ribbon panel that will bring together experts, governmental partners, and community leaders to put the recommendations of the National Task Force into practice in our courts. This is a weighty responsibility, but no one is better suited to the task than Judge Demick, who has presided over our Brooklyn Mental Health Court since its inception more than 20 years ago, and who unquestionably has the knowledge and vision to effectuate lasting reform. Thank you, Judge Demick. We have not lost sight of our mission to deliver equal justice to every person and entity that comes before our courts. Under the guidance of our Office for Justice Initiatives, led by Deputy Chief Administrative Judge Edwina Richardson Mendelson, we continue to work toward a more equitable, diverse, and inclusive court system. Consistent with recommendations from Secretary Johnson's Equal Justice Report, we have created and distributed mandatory bias training for judges, non-judicial staff, court officers, and uniformed personnel. The responses of our employees and the judiciary have been strong. But we understand that we must remain vigilant and proactive to ensure that implicit bias does not infect our work. We have adopted anti-bias training requirements for mediators, arbitrators, and neutral evaluators involved in court-sponsored alternative dispute resolution programs. These trainings will increase awareness and equip our ADR professionals with tools to combat bias and promote inclusivity. Our Court Officers Manual, which is currently being updated, will also now include anti-bias training materials. Through scores of programs, town halls, educational sessions, meetings with justice partners, and collaborations with our human resource departments, we have continued to raise awareness among our workforce, implement programs and trainings to strengthen the humanity and dignity in interactions between court personnel and litigants, implement programs and and guard against the blight of racism and bias both in and outside of our courtrooms. Responses to the juror orientation video rolled out last year to educate jurors on the dangers of bias have been overwhelmingly positive, and our courts have engaged directly with their communities to learn and improve, as reflected particularly well by the 7th Judicial District's Judicial Observation Project, a unique initiative in which specially trained community observers monitor courtrooms to help judges better identify and guard against unconscious bias. The unified court system has also devoted significant time and energy to community outreach. During Jury Week, Jessica Simard, our statewide jury coordinator, sponsored a week-long social media campaign to highlight the importance of jury service. Our Office for Justice Initiatives, local equal justice committees, judges, court officers, and staff have participated in career fairs, school visits, student tours, and civic engagement programs throughout the state. In the 3rd Judicial District, overseen by Administrative Judge Gerald Connolly, members of the local Equal Justice Committee have visited 11 schools, held 4 court tours, and attended several career fairs at institutions of higher learning. The 3rd Judicial District also secured funding for careers in the courts, recruitment video produced with the assistance of the Albany-based Youth FX, a company that strives to empower young people from diverse communities by teaching them the skills of digital filmmaking and media production. Our courts have also invested in the careers of our existing employees. During the immersive 2-day Professional Development Academy, the 6th, 9th, and 12th judicial districts provided helpful training to non-judicial employees in order to promote internal career mobility. Initiatives such as these ensure that underrepresented populations are provided with career advancement support and strengthen ties between our courts and their local communities. And with respect to the bar, we have heard that the legal community and legislature's concerns about the potential impact of question 26 on our bar admission application will have on diversity. Our administrative board is working in concert to consider and coordinate modifications to question 26, which pertains to arrest and conviction disclosures, in order to promote equity and inclusion in admission to the bar. And we expect to solidify our next step in that process very soon. I conclude our 2023 State of our Judiciary by addressing the unprecedented events surrounding the Chief Judge selection process and the unexpected duration of my interim service. First, I want to thank every single member of our court family for continuing to fulfill their duties with the utmost professionalism and care despite the recent uncertainties. I'm honored and humbled to have had the opportunity to serve in the role of acting Chief Judge for however long that service may ultimately be. Despite my years of service as an administrative judge before joining the Court of Appeals, I can sincerely state that I have learned more about our court system than I would have thought possible a year ago, and I am constantly amazed by the incredible talent, experience, and empathy brought to the table each day by our administrative and supervising judges, our court administration professionals, and indeed all members of our court staff. I extend a special and heartfelt thank you to Acting Chief Administrative Judge Tomiko Amaker. Judge Amaker is one of the most dedicated and hardworking judges whom I have had the honor of serving with. Over the last several months, Judge Amaker has done a fantastic job of overseeing the day-to-day administration of our entire court system, and she has been an invaluable source of operational knowledge, legal expertise, and sage advice. I could not have asked for a better partner in administering our court system. I also want to thank Presiding Justice Rolando Acosta for his many years of service to our court. Presiding Justice Acosta recently announced that he will soon be retiring after more than 25 years on the bench. After starting his judicial career in civil court and subsequently being elected to Supreme Court, Presiding Justice Acosta has steered the First Department for almost 6 years. During that time, P.J. Acosta made significant headway in modernizing the court's operations and ensuring that appellate justice is both efficient and accessible. He has left a lasting imprint on both the administration and the precedent of the First Department. We congratulate him on a well-deserved retirement and wish him luck in his future endeavors. It is also fitting for me to recognize Presiding Justice Hector D. LaSalle today. Presiding Justice LaSalle has dedicated his career to serving the public and our courts. We are lucky to have him as a jurist and as the administrative head of the Second Department, and I am personally deeply honored by his presence here today. Thank you, Justice LaSalle. On a final note, I want to remind everyone that this is not the first time that the New York Judiciary has weathered criticism and vigorous public debate about its proper role in our democracy. More than 25 years ago, the ever-prescient Chief Judge Judith S. Kay observed that in modern times, the ability of some to spin masses of information and manipulate the public is staggering. Chief Judge Kay recognized that our commitment to judicial independence nevertheless requires that judges impartially apply the law, which may at times be counter-majoritarian, may at times not be to their liking, and may at times not even make common sense to them personally. Judicial ethics preclude members of the bench from deciding matters that come before them based on personal, political, or religious views. And while our rulings may not always be popular at a given point in time, as Justice Ruth Bader Ginsburg cautioned during her confirmation hearings in response to questioning from then-Senator Joe Biden, society must always be mindful of the proper role of the judiciary because democracy can be destroyed if judges dare to rule as platonic guardians. Since its founding, New York's judiciary and the court system has supported the essential pillars of our democracy by delivering fair and impartial justice without regard to political persuasion or the headwinds of public opinion. That is not to say that the law does not advance or that it does not progress with society or modern values. Surely it does. But we must be cognizant of our motivations and our role in the tricameral system of government. We must stick to reasoned determinations and resist any temptation or pressure for outcome-oriented decision-making. We must follow and enforce the law as we understand it, zealously protect the principles embedded in the state and federal constitutions, and to borrow a phrase from presiding Justice Acosta, dispense justice without fear or favor. This our judiciary has done since its founding, and this I am confident we will continue to do. Thank you, and I look forward to working with all of you in the year ahead.
So thank you very much to our acting chief judge for those inspiring words. And thank you to all of you for all that you do and for being here today. Safe travels to everyone.